Hello everyone, let's continue where we left. And we have already completed the previous year question paper of AIB 17 up till 17. Um, I think we have started from AIB 3 or 4, whatever that was, and already have completed up till yet, up till 17, and this one is 18, AIBE 18 previous year question paper, and let's try to discuss the right answer of each and every question. The first one is saying which of the following is incorrect with respect to diary of proceedings in investigation as per the Code of Criminal Procedure 1973. Its right option is option C, that is the diary may be used as evidence. So basically, as we all know, the diary, the police diary that is meant, uh, basically that is maintainable by the police officer. We can't use that as an evidence, so the right answer is the diary may be used as evidence. We have to tick mark the incorrect option, so this one is incorrect option, this one C. Next question is question number 2. In which of the following cases manner of committing offense is not required to be mentioned in the charge as per the Code of Criminal Procedure 1973? The right option is option A, that is A is accused of theft of a certain article at a certain time and place. So basically if you have seen the form, उसमें ये सारी चीज़ें ऑलरेडी मेंशन होती है कि चोरी की है नहीं की है, अगर किया है तो आर्टिकल क्या क्या थे, टाइम क्या था, तो इसमें ज़्यादा रिक्वायरमेंट नहीं है। इसमें चार्जशीट जो है कम्प्लीटली फुल ऑन जो है मेंशन करने का, वो कम्प्लीटली रिक्वायरमेंट नहीं है, तो ये जो है शॉर्ट वे में भी इसमें काम चल सकता है। सो दैट्स व्हाई इट्स राइट आंसर इज ऑप्शन ए। लेट्स मूव टू द नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 3. What it's saying, which of the following offences may be tried summarily as per the Code of Criminal Procedure 1973? The right option is option uh, question number 3. Here there is a fault here, not is missing, not, as per I have made the research, so that's why it's a this question is not right. So uh, there were highly chance that the students will get, and the aspirants or whatever the candidates will get the one grace marks in this question. So because of the fault in the question, so we don't have the right answer in this question. Let's move to the next question, question number 4. Which of the following may be tried summarily? So basically section 454 can be tried summarily, 504 can also be tried summarily, offense punishable with imprisonment for term not exceeding 2 years can also be tried summarily, offenses punishable with life imprisonment summarily, may be tried summarily. नहीं, इसका आई थिंक सी होगा, offense punishable with wait, which of the following offences may be tried summarily as per the Code of Criminal Procedure 1973? Offences punishable with imprisonment for term not exceeding 2 years. The right option is option C. This can be tried summarily. Next question, question number 4. Which of the following section of the Code of Criminal Procedure 1973 provides for reference to High Court? The right option is option D, that is section 395. Next question, question number 5. A person accused of the following offence may not be granted bail under section 438 of the Code of Criminal Procedure 1973. The right option is option D, that is first, second, third, first, second, and third, all. Accused of offences under section 376 AB of IPC, under section 376 DA of IPC, and under section 376 DB of IVC. So the right option is option D, that is first, second, third, all. Question number 6. Which of the following act, if done by any magistrate, even in good faith, without being empowered, shall vitiate the proceedings as per the Code of Criminal Procedure 1973. The right option is option C, that is attaches property under section 83 of the CRPC. Even in good faith, without being empowered, shall vitiate the proceeding as per the Code of Criminal Procedure 1973. The right option is option C, that is attaches property under section 83 83 of CRPC. Question number 7. Which of the following is material? Which of the following is material for deciding the jurisdiction of the civil court in the light of Code of Civil Procedure 1908? Option B, have averments made in the plaint. Option B, averment made in the written statement. Option C, both A and B. And option D, neither A nor B. The right answer should be option C, that is both A and B. So sorry, wait. Which of the following is material for deciding the jurisdiction of civil court in the light of Court of 1908? So sorry. Basically, its right option is option A, averments made in the plaint. तो जो भी प्लेंट में लिखा रहता है तो उसके थ्रू हमें पता चलता है कि मैटर जो है वो सिविल मैटर में क्यों आया है और एक्चुअल में वो सिविल मैटर है या नहीं है. So its right option is option A, that is averments made in the plaint. Next question, question number 8. Which of the following cannot be considered as the suit of civil nature for the section 9 of the Code of Civil Procedure 1908? Options that we have: suit for recovery of voluntary payment or offering, suit for right of franchise, suit for a specific relief, suit relating to right of worship. ये तीनों तो आ सकते हैं. Suit for recovery of voluntary payments और ऑफरिंग्स इसके लिए सूट नहीं कर सकते कि आप जो है आप को मैंडेटरीली पैसा पे करना ही करना है. ठीक है, कोई चैरिटी हो गई या फिर मंदिर में गए वहाँ पे दान वगैरह जो है आपको मैंडेटरीली करना ही करना है तो वो उसकी उसमें सूट नहीं कर सकते हैं. ठीक है, वो सामने वाले व्यक्ति की श्रद्धा होती है. ओके. द नेक्स्ट क्वेश्चन इज क्वेश्चन नंबर 9. विच ऑफ द फॉलोइंग प्रोविजन of Code of Civil Procedure 1908 makes the doctrine of res judicata applicable in representative suit? The right option is option B, that is section 11, explanation 6. Question number 10. In which of the following situations a court will not issue summon for personal appearance to the defendant? If the defendant reside within the local limit of the court jurisdiction, if defendant reside within 40 miles from court, defendant reside 250 miles, movement to whom section 132 of Civil Procedure Code 1908 does not apply. Its right option is option D, that is a woman to whom section 132 of Civil Procedure 1908 doesn't apply. What basically section 132 talks about कि कोई भी व्यक्ति ऐसी है, कोई भी महिला ऐसी है, जो कोई भी व्यक्ति ऐसा है, या मतलब महिला बेसिकली ऐसी है कि वो पर्दा प्रथा फॉलो करती है और वो बाहर नहीं जाती है. तो कभी वो बाहर निकली नहीं तो उसने अपना एक जो है एक फ्रेम सेट कर लिया कि मुझे लोगों के सामने नहीं आना है. तो वैसे अगर पर्सन वैसा कोई व्यक्ति है तो उसको कोर्ट जो है वो नहीं बुला सकता है. Section 11. In which of the following situations plaintiff is precluded from bringing a fresh suit as per the Code of Civil Procedure 8? Dismissal of suit where summon not served in consequence of plaintiff's failure to pay cost, become neither party appears. did not appear, dismissal of suit because plaintiff did not apply for press summon within given time limit once it. Its right option will be option C, that is dismissal of suit in because plaintiff did not appear. तो अगर plaintiff आया ही नहीं तो मतलब उसको शिकायत ही नहीं है, और शिकायत ही नहीं तो फिर कंप्लेन किस बात का, उसको भी हटा दिया जाता है. तो दिस इज द थिंकिंग ऑफ द कोर्ट. एंड उसके बेसिस पे अगर प्लेंटिफ नहीं आता है तो सूट जो है वो सूट जो है उसको रिजेक्ट कर दिया जाएगा एंड फिर वो फाइल नहीं कर सकते हैं. क्वेश्चन नंबर 12, हाउ मेनी टाइम्स एट मैक्स में an adjournment be granted to a party during hearing of suit as per Code of Civil Procedure 1908? The right option is option B, that is 3 times. And I have written it's a like a provision, but somewhere I am confused in between B and D. Okay, so as far as I know, we can go with B. Okay, 3 times. I forgot to mention the relevant section of that for that. So we have to do some research work too, you and me both. Question number 13. Which of the following Amendment Act made the provision in the Code of Civil Procedure 1908 to produce a witness without a summon? Its right option is option A, that is the Code of Civil Procedure Amendment Act 1976, if I am not wrong. Yeah, its right option is option A, that is the Code of Civil Procedure Amendment Act 1976. Question number 14. Which of the following is not included in the word cost as provided under the Code of Civil Procedure 1908? The right option is option C, that is fooding and lodging expenses incurred. इसके अलावा ये तीनों के पैसे जो है आपको मिल जाएंगे अगर आप केस जीते हैं तो, लेकिन इसका नहीं मिलेगा. Question number 15. What period is prescribed under the Code of Civil Procedure 1908 for defendant to enter an appearance for filing address for service of notice on him in case of a suit where summary procedure is to be applied? The right option is option B, that is 10 days from the date of receiving of summons. Only apply where the suit can be go with summary procedure. So in that case, within 10 days, within 10 days from receiving of summons. Question number 16. Under which of the following provision of the Code of Civil Procedure 1908 the appellant court may remit an issue for trial to lower court? Its right answer is option D, that is Order 41, Rule 25. Question number 17. A is accused of murder of B by beating him. Which of the following will not be considered as relevant fact forming part of the same transaction as per the Indian Evidence Act 1872? The options we have wherever said by A or B at the time of beating, whatever said by A or B at the time of beating. Option B, whatever done by A or B at the time of beating. Wait, A is accused of murder of B by beating him. Which of the following will not be considered as relevant fact forming part of same transaction as per the Indian Evidence Act? Said whatever said by A or B, whatever said at the time of beating, whatever done at the time of beating, whatever said by standards, whatever said by A or B a day before the day of beating. The right answer will be option D, that is whatever said by A or B a day before the day of beating. ठीक है, तो हवा में मैंने इन केस मान लो अगर एक दिन पहले वो कुछ हवा में बात कर रहे थे तो यार वो कर सकते हैं, तो उसको रिलेवेंसी नहीं दी जाएगी क्योंकि हमारे पास ऑप्शन ही यही है. अब इनमें से सबसे सुटेबल ऑप्शन ऑप्शन डी है, एज सिंपल एज दैट. हालांकि कॉन्स्पिरेसी में ये भी कवर हो जाएगा, लेकिन ये ऑप्शन ही 4 ये है, तो इसमें से जो है राइट आंसर है ऑप्शन डी, दैट इज वट एवर सेड बाय, क्योंकि ये सारे रिलेवेंट है, ठीक है, जो मारते समय उन्होंने जो बोला, ठीक है, या फिर जो भी उन्होंने मारते समय बोला, या फिर जो भी उन्होंने मारते समय किया, या फिर जो भी मारते समय जो वहाँ के लोग देख रहे थे, वो सब रिलेवेंट है। लेकिन एक दिन पहले की अगर बात की जाए, तो क्योंकि हमारे पास ऑप्शन ही वही है, तो ये सबसे इररिलेवेंट लग रहा है, तो ये ऑप्शन डी, so this is this will not become in as a relevant fact. Question number 18, which of the following provision of Indian Evidence Act 1872 says that the confession to police officer shall not be proved against him? Its right option is option B, that is section 25. Question number 19, under which of the following provision of the Indian Evidence Act 1872 dying declaration may be admitted as evidence? The right option is option C, that is section 32 of Indian Evidence Act 1872. Question number 20, which of the following is correct according to the Indian Evidence Act 1872 pertaining to proof of content of the documents? The right answer will be option D, that is content of documents may be proved either by primary or by secondary evidence. Question number 21, which of the following is a correct statement as per the Indian Evidence Act 1872? Leading question may be asked in cross examination. This is the right option, option B, that is leading question may be asked in cross examination, not in not while examination in chief, not while re-examination, but in while cross examination. So the right option is option B, that is leading question may be asked in cross examination. Question number 22, in which of the following case did the Supreme Court of India clarify the admissibility of electronic record as evidence? The right option is option A, that is Anwar PV versus PK Basir. Question number 23, which of the following is incorrect statement in the light of Indian Evidence Act 1872? Right option will be option B, that is admissions are conclusive. Admissions are conclusive as to the matter admitted. As to the matter admitted. Question number 24, which of the following section of the Indian Evidence Act 1872 is an exception to the hearsay rule? The right option of question number 24 will be option A, that is section 32 subsection 1. So the right option is option A. Question number 25, which of the following is not a recognized alternate dispute resolution mechanism under the Code of Civil Procedure 1908? We will see this language in section 89, in which it is visibly mentioned that arbitration is a part of alternative dispute resolution mechanism, also the conciliation, and also the lok adalat, but not the negotiation. Okay, so the right option will be option D, that is negotiation. Question number 26, which of the following is incorrect statement with respect to lok adalat? That option B, that lok adalat can deal with all civil and criminal matters, not all but a few portion of civil and criminal matters, but not all civil and criminal matters. So the right option is option B. We in this question we have to tell the incorrect statement, and the incorrect statement is mentioned in option B. So the right option of this question number 26 will be option B, that is Lok Adalat can deal with all civil and criminal matters. Okay, let's pause this video here only, and we will continue it in next part.